Welcome back. I'm going to talk about why the Social Security disability standard of disability is not the same thing as a disability insurance policy definition of any occupation. Now, I'm a Social Security disability attorney in addition to being an ERISA disability attorney. And I get this question all the time from clients and prospective clients. So let's talk about the Social Security definition of disability. The Social Security Act defines disability for adults as the inability to engage in substantial gainful activity by reason of a medically determinable physical or mental impairment. So the disability in question has to be expected to end in death, or one of which is going to last or is expected to last for at least a minimum period of 12 months. So get out your disability policy, like I told you. Does that definition of disability that I just told you look like, sound like the disability definition in your policy? The answer is generally no. Now, the Social Security Administration also uses a 5-step sequential evaluation to determine entitlement to benefits. And it's a sequential evaluation process. The first question they ask is, have you been out of work for at least a year? Or do you have a condition that would keep you out of work for at least a year or result in your death? Next, is your disabling impairment temporary or permanent? So is it like a sprain or strain or something that's going to heal, or is it going to last longer, at least 12 months? Do you meet what's called a medical listing? What on earth is a listing? Well, the Social Security Administration uses a listing of impairments to evaluate the severity of most mental and physical conditions. It's called the Blue Book, the listing of impairments. But to meet a listing, your condition has to document specific medical findings and symptoms that have resulted in significant and specific functional limitations. The bottom line is, if your medical records don't document all of the elements of a listing, you aren't going to be found disabled at step 3. Now, happily, if your records document that your condition meets or meets a listed impairment, you're going to be found disabled. But in my experience as a Social Security attorney, that just doesn't happen very often. And part of the reason is that doctors didn't go to medical school to learn how to write their reports for Social Security disability purposes, much less long-term disability purposes. So as a result, most Social Security disability applicants don't meet a listing because of the way their medical records have been compiled. So if you don't meet a listing at step 3, we go to steps 4 and 5, which are medical and vocational in nature. And what I mean by that is, the question is, on the one hand, what are your restrictions and limitations, both physically or psychiatrically? And secondly, do you meet the necessary vocational tests at step 4 and 5? At step 4, the issue is, can you go back to the lightest physically or simplest demanding job you held in the 15 years before you became disabled? Now, at step 5, even if the Social Security Administration determines that you can't return to your past relevant work, you may not have won your Social Security case. And it really depends on your age. But you have to go on to step 5. And at step 5, the burden of proof shifts from you to the Social Security Administration. They've got to show that you've retained the capacity to perform other work that exists in significant numbers in the national economy in view of your age, education, transferable skills, and restrictions. Did you hear that operative word? Age. Age is generally not a factor in the definition of disability in a disability insurance policy. It's a key factor in a Social Security claim. Disability carriers have to at least acknowledge a Social Security award in evaluating your case based on a U.S. Supreme Court case called MetLife versus Glenn. But they'll explain away that Social Security favorable decision on the basis that there's a different standard and that age is a key factor in determining your entitlement to benefits. So that's why the definition of disability for a Social Security case is rarely the same as a long-term disability definition of disability. Got it? All right, let's take another break.
Are you a professional with questions about your individual disability policy? You need the Disability Insurance Claim Survival Guide for Professionals. This book gives you a comprehensive understanding of your disability policy, with tips and to-dos regarding your disability application that will assist you in submitting a winning disability application. This is one you won't want to miss. For the next 24 hours, we are giving away free copies of the Disability Insurance Claim Survival Guide for Professionals. Order yours today at disabilityclaimsforprofessionals.com.